This eyesore comes down today. Start swinging.
That's what the HOA president screamed at the two contractors standing beside my wife's wheelchair ramp with sledgehammers in their hands. Marin was on the porch in the chair, 6 feet away. She'd been in that chair for 14 months since her stroke. The ramp was the only way she could get from our driveway to our front door. I had built it with my own hands to every ADA specification. The HOA president had personally denied our federal fair housing accommodation request 3 weeks earlier. She thought a Saturday morning sledgehammer would settle the matter. She didn't know I had spent 24 years as an Army combat medic. She didn't know my daughter is an occupational therapist with a HUD complaint number on her phone. She didn't know the federal judge 6 houses down had been quietly building a file on her for 2 years. So I didn't shout. I started recording. Tell me below, would you have stopped them or let her swing on camera? My name is Holt Ashford, and my wife Marin and I live at 4218 Antler Ridge Drive in Larimer County, Colorado, about 20 minutes north of Fort Collins. The house is a 2018 Craftsman on a quarter-acre corner lot in a development called Antler Ridge Estates. We bought it the spring after I retired from the United States Army at 24 years. I served 24 years as an Army combat medic, 4 years enlisted, and 20 as a senior NCO. The last 6 were as a master sergeant assigned to the 10th Mountain Division. I deployed twice to Iraq and 3 times to Afghanistan. I have a chest full of ribbons I do not display. I do not talk about most of it. I will tell you that the work taught me 3 things: how to think clearly when the noise is loudest, how to keep a calm hand on someone whose body is not cooperating, and how to write down everything that happens in a notebook with the date, the time, and the names. Marin was an elementary school librarian for 28 years at Cache Laputer Elementary. Before that, she was a children's librarian at the Loveland Public Branch. She has read aloud to 4 generations of kids in this county, and she remembers most of their names. We have one daughter, Greta, who is 26 and works as an occupational therapist at Children's Hospital Colorado in Denver. Greta drives up most weekends now. 14 months ago, on a Wednesday afternoon in February, my wife had a hemorrhagic stroke at the dining room table. I was at the community college teaching an emergency airway lab when it happened. Marin had been finishing a crossword puzzle. She made it to the kitchen. She got the phone in her left hand. She dialed 911 and stayed on the line for the 11 minutes it took to get her to UC Health Poudre Valley. The neurologist would later tell me that her composure on that phone call was probably the reason she was still able to recognize me. I walked into the trauma bay an hour later. She was in the hospital for 9 weeks, inpatient rehab for another 7. She came home on a soft June morning in a wheelchair, with the right side of her body still on a long, slow journey back. She has been in physical therapy 4 days a week for 11 months since. Her speech is back. Her mind has never wavered. The right side of her body is on its own clock. She uses a walker for short trips inside the house, and the chair for everything outside. The ramp was the first thing I built when I knew she was coming home. I built it with my old Army friend Ezekiel Wittenberg, who runs a small custom carpentry shop in Loveland. We used clear-grain Western red cedar from a mill in Glenwood Springs. We followed every published ADA accessibility standard for residential ramps. 1 to 12 slope, 36-inch clear width, continuous handrails on both sides at 34 to 38 inches, anti-slip surface treatment, a 4x4 landing at the porch, a 4x4 landing at the bottom, stained to match the house trim, sealed for Colorado winters. I built it in 9 days. I paid $1,700 in materials. Zeke did not let me pay for his labor. Marin rolled up that ramp on a Tuesday morning in early July with both of our daughters' high school graduation photographs in her lap. She cried twice. So did I. The first letter from the Antler Ridge Estates Homeowners Association arrived 4 days later. Cream paper, gold foil HOA crest, signed in the looping cursive of Madam President, Whitney Bramwell. The letter informed me that an unapproved exterior modification had been observed at our property. It directed me to submit a modification request form within 14 days. The form must be accompanied by a $500 processing fee, an architectural review packet, and a written statement of intended duration of the modification. I read the letter twice on the porch with my coffee. Marin read it once and asked me, in the careful, clear voice she uses now, what kind of person sends a letter like that? I told her I did not know yet, but I would. I filled out the modification request form the same week, in clean engineer's printing, with every ADA reference, every dimension, every material specification. I attached photographs of the completed ramp from 4 angles. I attached a copy of Marin's hospital discharge summary, with her medical condition redacted, only to the extent required. I attached a written request for a reasonable accommodation under Title VIII of the Civil Rights Act of 1968, the Federal Fair Housing Act. I waived the $500 processing fee request on the constitutional ground that a fee for a federally protected reasonable accommodation is itself an act of discrimination. I delivered the packet to the Antler Ridge Estates HOA office on a Tuesday morning. The young woman at the desk read the cover sheet and offered me a cup of coffee. I accepted. Whitney Bramwell's response took 8 days. It came in the form of a denial letter, signed personally by Madam President. The letter denied the modification request on aesthetic grounds. It said the ramp fundamentally alters the aesthetic character of the property and violates Antler Ridge Estates Architectural Standards Section 8.4. It denied the reasonable accommodation request on the grounds that the homeowner has not provided sufficient documentation of permanent disability. It directed me to remove the ramp within 30 days. It assessed an interim daily fine of $200 per day until compliance. Marin read the letter once. She did not say anything for a long minute. Holt, she wants a permanent disability letter from the doctor. She wants a permanent disability letter from a stroke patient who has been walking in the parallel bars for 11 months. Do I look permanent to her, Holt? I did not have a good answer for that. I drove down to the federal building in Denver the next morning. The U.S. Department of Housing and Urban Development office had a public intake counter on the 3rd floor. The counter was manned by a careful man named Chad Wexler. He had been processing fair housing complaints in the mountain region since 2003. I sat with him for 2.5 hours. We filled out a HUD 903 form together. He filed it with my name and case number before I left the building. While I was driving home, Whitney Bramwell published the next monthly issue of the Antler Ridge Estates Community Newsletter. The newsletter was a glossy production she wrote and edited herself. The lead article was a 1-page editorial titled, "Maintaining Architectural Integrity in a Changing Community." The article did not name us. It did not need to. It described an unnamed corner lot homeowner whose recent wooden installation had compromised the streetscape and was depressing comparable sales values for adjacent properties. It urged the community to stand united for our shared aesthetic standards. I came home to find Marin on the porch. Her cheeks were the color they had been the morning of the stroke. She did not say anything. She handed me the newsletter. I read it twice on the porch. Holt, they are going to make this about my body. They are going to try, sweetheart. We are going to make it about the law. The next morning, Friday at 7:15, a Ford F250 pulled into our driveway with 2 men in work clothes and a rolled-up tape measure. They had been told by Whitney Bramwell, on a printed work order, to perform pre-removal site measurements of the ramp. The work order was signed. They had not seen the property owner. Marin was in her chair on the porch with her morning coffee. Both men froze when they realized she was there. The older of the two, a man named Curtis Vega, took off his cap. He walked up to the porch slowly. He apologized to my wife in 3 different sentences before he had even introduced himself. "Ma'am, I am so sorry. We did not know. The work order said the structure was an unapproved addition. It did not say it was." He stopped. He looked at the ramp. He looked at the chair. "Ma'am, we are going to leave. I am going to need you to give me a phone number for somebody who can talk to us in writing. I do not want to be on the wrong side of whatever this is." Marin gave him my number. Curtis Vega and his crew were back in their truck and gone within 4 minutes. Curtis Vega called me at 9:15 that morning. He called me himself, from his own phone, on his own initiative, before I had even seen his missed call. "Mr. Ashford, I want to give you a sworn statement." The emergency board meeting was scheduled for the following Wednesday at the Antler Ridge Clubhouse. Whitney Bramwell did not put it on the public agenda. She did not post the meeting notice on the community board. She sent it via personal text to the 3 other board members she counted on. The notice landed in their phones at 4 o'clock on a Tuesday afternoon. The meeting started at 7 the next evening. Otto Reiner, a retired electrician from 4147 Antler Ridge, had served on the original Antler Ridge Estates Board in 2018. He had been forced off in 2021 after he had asked too many questions about a clubhouse renovation contract. The contract had gone, without competitive bidding, to a Bramwell associate, Otto found out about the Wednesday meeting Tuesday evening from his next-door neighbor, who was on the text list and who was already uncomfortable. Otto walked across the cul-de-sac to my house Wednesday morning at 7 a.m. He carried a tin of his late wife's chocolate chip cookies and a yellow legal pad full of names. Holt, there are at least 4 other households at Antler Ridge that have been bullied by that woman over disability and family medical accommodations. I have been keeping a list since 2022. I think you and I need to talk. We talked for 90 minutes. By Wednesday afternoon, Otto Reiner had called every name on his list. 3 of the 4 households agreed to come to the meeting. The 4th was the family of an 11-year-old autistic boy who had been cited for using a small, noise-attenuating sensory tent on his front lawn. They were also already in contact with HUD. By Wednesday evening at 6:55, 14 of Whitney Bramwell's neighbors walked into a board meeting she had tried to keep private. Otto Reiner walked in first. I came in second, with Maren in her chair. Ezekiel Wittenberg, the retired Air Force chief who had built the ramp with me, came in third. Behind us came the Stickney family with their 11-year-old son. Behind them came a couple named the Brierleys, whose adult daughter had spent 8 years in a wheelchair after a Loveland car accident. Behind them came 2 retired school teachers named Lillian Crowell and Ardith Pelham. Both were widows of Vietnam veterans. Both had received compliance notices over portable oxygen units on their porches. Whitney Bramwell sat at the head of the long table with 3 board members. She did not stand when we walked in. What followed was the worst attended secret meeting in Antler Ridge Estates history. Whitney read aloud from a prepared resolution titled, Antler Ridge Estates Emergency Aesthetic Enforcement Resolution. The resolution would empower the board, by 3-to-1 majority, to summarily authorize removal of any non-compliant exterior modification without further owner notification. It would also designate certain medical or accessibility installations as falling under aesthetic review. She read the resolution in the steady, polished voice of a woman who had practiced it in a mirror. Otto Reiner stood up when she finished. Madam President, Section 8.4 of our bylaws is currently the subject of a federal HUD complaint filed by the Ashfords. 3 other households in this room are also in active contact with HUD. The resolution you have just read aloud will be added to the federal complaint. It will be added the moment it is voted on. It will be evidence of pattern or practice retaliation. Whitney's face did the thing she would later do at the Saturday morning sledgehammer event. Mr. Reiner, the resolution is procedurally appropriate. Madam President, the resolution is illegal, and I am not the only one in this room who knows that. I stood up. I helped Maren stand up. I held her right elbow. We walked together to the front of the table. Maren did not need a podium. She spoke clearly, slowly, the way she has spoken for 14 months now. Mrs. Bramwell, the ramp is the only way I get into my house. You know it. Everybody at this table knows it. If you vote on that resolution, you will be voting to make it harder for me to come home at night. I want every person in this room to look at me when you raise your hand. The 4-member board voted 4-0 not to bring the resolution to the floor. Whitney Bramwell did not speak again that evening. We walked out of the clubhouse at 7:46. Otto Reiner walked next to me. He did not say anything for a block. Then, before he turned off toward his own driveway, he said it. Holt, she is not done. He was right. 3 days later, on a Saturday morning at 6:30, 2 contractors with sledgehammers arrived in my driveway. The 2 men in the driveway at 6:30 Saturday morning were not Curtis Vega's crew. Curtis had quit working for Whitney Bramwell after the Friday morning visit 2 weeks earlier. These were 2 younger men in a Ram 1500 with no decals. Whitney had hired them off Craigslist in cash the night before for $400 apiece. They had been told the property was vacant. The structure was an unauthorized addition, and the owner had been formally notified. Whitney's champagne Cadillac pulled in behind their Ram at 6:33. I had heard the trucks the moment the first one turned the corner. Maren and I had been awake since 5:15, because that was when Maren's medication schedule said she was awake. I was in jeans and a clean white t-shirt. I had a body-worn camera clipped to my collar. I had bought it the week of the first violation notice. I had been wearing it on the property ever since. I walked out the front door with my coffee. Maren rolled out behind me in the chair. The 2 younger men stood beside the bottom landing of the ramp, with their sledgehammers down at their sides. They had not started yet. They were waiting on the woman with the clipboard. Whitney got out of her Cadillac with the clipboard in her hand. She wore the bright, brittle smile of a woman who had decided this Saturday morning was going to be settled before sunrise. Mr. Ashford, Step back. The board has authorized removal of the unapproved structure under the emergency aesthetic provision. Mrs. Bramwell, there is no emergency aesthetic provision. The board voted 4-0 against it on Wednesday. Mr. Ashford, the provision was passed by executive authority Friday morning. There is no executive authority in your bylaws, Mrs. Bramwell. She turned to the two men. Begin removal. The older of the two looked at me. He looked at Marin in the chair. He looked at the camera clipped to my collar. Sir, is this your property? Yes. The woman with the clipboard does not have authority to order this removal. There is a federal HUD complaint on file. There is a state civil rights complaint on file. If you swing that hammer, you will be on body camera, and you will personally be named in the federal action. The older man set his sledgehammer down on the gravel. The younger man hesitated for 1 full second. That was when Whitney Bramwell walked forward, around the older man. She put both hands on the handles of Marin's wheelchair. She tried to roll my wife backward off the porch. I have spent 24 years putting calm hands on bodies that were not cooperating. I crossed the 4 feet between us in the cleanest interception of my life. I lifted Whitney Bramwell's hands off the chair. I placed them, one at a time, back at her sides. I did not raise my voice. I did not touch her again. The body camera caught all of it in 4K resolution at 30 frames per second. Mrs. Bramwell, you will not touch my wife. Step back to your vehicle. She stepped back to her vehicle. The older contractor was already on his phone, calling the Larimer County Sheriff's non-emergency line on his own initiative. 3 sheriff's cruisers arrived at 6:51. Sheriff's Deputy Wade Kerrigan was a 4th-generation Larimer County deputy. I had taught him how to insert a chest tube in a community college EMT class 4 years earlier. He took the body camera footage on a thumb drive. He took a written statement from me, from Marin, and from both contractors. He took a 5th statement from Otto Reiner, who had been watching the entire event from his front porch with binoculars and his own phone on record. By 8 in the morning, Whitney Bramwell had been issued a court summons for second-degree harassment, criminal trespass, and disability-targeted harassment under Colorado Revised Statute 18-9-121. By 9 in the morning, Sutton Maddox of the Colorado Cross Disability Coalition was at our kitchen table. Sutton was a 43-year-old civil rights attorney who had argued 2 ADA cases at the 10th Circuit. She watched the body camera footage twice. She did not say anything for a long minute. Holt, Marin, we are filing for an emergency federal injunction Monday morning. Sutton Maddox set up shop at our dining room table on Sunday morning at 7 a.m. She brought 3 banker's boxes, a federal docket printer, and an industrial coffee thermos. By noon, she had served Whitney Bramwell with a Federal Rule 65 emergency injunction notice through the Larimer County Sheriff's Office. The hearing was set for Friday afternoon, 4 days out, before Judge Patricia Carlton of the United States District Court for the District of Colorado. By 3 in the afternoon, Otto Reiner had come over with a handwritten list of every household at Antler Ridge Estates that had received a Bramwell compliance notice in the past 4 years. The list contained 26 households. 11 of those households had received notices related to medical or accessibility accommodations. Of those 11, 9 had paid the fines or removed the modifications without contesting. 2 had moved out of the neighborhood entirely under sustained pressure. The Stickneys, with the 11-year-old autistic boy, were the only family besides ours that had openly fought back. Sutton called HUD. Sutton called the Department of Justice Civil Rights Division. Sutton called Bryn Anderson, a colleague of hers at the Cross Disability Coalition, who specialized in pattern or practice cases. By 6 in the evening, Sutton had what she described as a textbook FHA, pattern or practice file. She said it with the level satisfaction of a civil rights attorney who has been waiting for this exact case for 15 years. That was when our doorbell rang. The woman on our front porch was about my age, in jeans and a faded University of Wisconsin sweatshirt and a pair of muddy garden clogs. She had short silver hair and the steady eyes of someone who has been listening carefully for a long time. I had seen her before in the neighborhood. I had not known her name. Mr. Ashford, I am your neighbor at 4194. My name is Eleanor Whitfield. I am a federal district court judge. I would like to speak with you and your wife if you have a few minutes. Marin rolled to the door before I could answer. Eleanor Whitfield came inside. She sat at our kitchen table with a cup of coffee in her left hand and a manila folder in her right. The folder, she explained, contained 2 years of documentation. She had been quietly assembling it on Whitney Bramwell's HOA conduct toward residents with medical accommodations and minority status. Judge Whitfield had been on the receiving end of 3 Bramwell compliance notices herself. 2 were over a non-Christmas Hanukkah window display. 1 was over a Black Lives Matter sign she had displayed in her front yard during the summer of 2020. She had not made a formal complaint. She had said almost nothing publicly. She had simply documented everything. Date, time, letter contents, witness names, photographs. Mr. Ashford, I cannot hear your case. I will recuse the moment any matter touching this neighborhood lands on my docket. But I am also a citizen, and I am also your neighbor, and I would like to give you my file. There are 9 separate incidents in this folder. 5 of them were aimed at residents with disabilities. 2 were aimed at residents with school-age children with special needs. 2 were aimed at me on grounds of religious display and protected speech. Whatever your attorney does with this file, it is yours. Sutton Maddox took the folder with both hands. Your Honor, thank you. Sutton, tonight I am Nora. You and I will work this from opposite sides of the lawn. Judge Eleanor Whitfield drank her coffee. She looked across the table at Marin in the chair. Mrs. Ashford, the ramp is beautiful. I have admired it for 14 months from my driveway. I am sorry I did not introduce myself sooner. Marin smiled. She has a smile that has not changed since the morning of the stroke. Judge, we are very glad you came tonight. The 4 days between Sunday evening and Friday afternoon turned my dining room into a federal civil rights litigation operation. Sutton Maddox worked 16-hour days. Bryn Anderson drove up from Boulder Monday morning and stayed in our spare room. Greta drove up from Denver Tuesday with her clinical director, Dr. Claudine Hartwell. Dr. Hartwell had been an OT for 31 years. She had served as an expert witness in 18 federal ADA cases. Dr. Hartwell walked the ramp 3 times with a measuring tape and a clipboard. She declared, on a notarized affidavit, that the structure not only met every applicable ADA accessibility standard, it exceeded the requirements in the categories of slip resistance, handrail continuity, and landing dimensions. Otto Reiner gathered written statements from 12 households at Antler Ridge Estates. 8 of them confirmed they had received Bramwell compliance notices over medical or accessibility accommodations and had paid fines or removed equipment under duress. 4 of them volunteered to testify in open court if subpoenaed. Judge Whitfield's 2-year documentation file added another 9 incidents and 73 pages of corroborating photographs. The Stickney family's 11-year-old son, named Wesley, signed his own short statement in his own clean cursive in front of his parents. The statement said simply, "Mrs. Bramwell told me my tent was ugly. My tent helps me feel calm. I made it myself with my mom." Sutton Maddox cried for the first time the night she read Wesley's statement at our kitchen table. She did not cry again all week. By Tuesday evening, the federal complaint had been amended from a single plaintiff FHA case into a 5-household pattern or practice case. By Wednesday afternoon, Special Counsel Brian E. Eames of the U.S. Department of Housing and Urban Development Field Office in Denver had filed a notice of intervention. The intervention was on behalf of the United States government. HUD does not intervene in private FHA cases lightly. They had decided to intervene in this one. By Wednesday evening, Special Agent Adelaide Quintrell of the FBI Civil Rights Section had requested copies of every document in the case. The FBI does not request documents on private cases lightly. They had decided to monitor this one. By Thursday morning, a courier from the law firm representing Whitney Bramwell delivered a settlement offer to Sutton Maddox's office in Denver. The offer was $45,000 in exchange for dismissal with prejudice of all claims, plus a non-disclosure agreement. Sutton called me from the car. "Holt, they are panicking. They want to make this go away before Friday's hearing." "Sutton, we are not signing an NDA." "I know. I want every disabled neighbor at Antler Ridge to be safe. I want the bylaws fixed. I want the pattern documented in a public federal court record. No future Bramwell should ever be able to pretend it did not exist." "Holt, that is exactly the answer I was hoping you would give." She rejected the settlement on Thursday afternoon. Friday at 1:30 in the afternoon, Marin and I drove down to the United States District Courthouse in Denver in our truck. Greta drove with us. Otto Reiner followed in his own pickup with the Stickneys. Sutton had reserved a row in the front of courtroom 4. Brian E. Eames sat at the government's table with a yellow legal pad. Judge Patricia Carlton heard arguments for 2 hours. She did not deliver an oral ruling. She told both sides she would issue a written order before 5 o'clock. The written order came at 4:43. Judge Carlton granted the preliminary injunction. She enjoined the Antler Ridge Estates Homeowners Association from enforcing any aesthetic standards bylaw against the Ashford property, pending final adjudication of the FHA case. She enjoined Whitney Bramwell, personally, from approaching the Ashford property, pending final adjudication. She ordered the HOA to immediately pay the daily fines back into a court-supervised escrow. She set a status conference for 30 days out and a full trial date for 90 days out. The order was 23 pages. Sutton Maddox printed 2 copies in the Courthouse Business Center and handed me one before we drove home. "Holt, tomorrow morning your neighbor is going to deliver this to Mrs. Bramwell on her own front lawn. She and I have already worked out the choreography." I drove home with the order in the seat between me and Marin. Marin read the first 11 pages out loud before we hit Loveland. She finished the rest of it on the porch at sundown. Friday evening, the phone rang at 6:50. The voice on the other end was Theron Bramwell, Whitney's husband. He owned a small commercial development firm that built strip malls along the I-25 corridor between Fort Collins and Loveland. I had not met him. I had seen him twice in the neighborhood, both times in the passenger seat of his wife's Cadillac. "Mr. Ashford, this is Theron Bramwell. I am calling to apologize personally for what happened to your property and to your wife last Saturday. I want you to know I had no part in it. I want to discuss a quiet resolution." I let him talk for 2 minutes. "Mr. Bramwell, the federal court has already issued a preliminary injunction. The Department of Housing and Urban Development has intervened on behalf of the United States. The FBI Civil Rights Section is monitoring. The horse left the barn at 4:43 this afternoon. The barn is now a federal exhibit." There was a long quiet on the other end. "Mr. Ashford, is there anything I can do?" "Yes, Mr. Bramwell. Tell your wife to be ready to receive a federal court order in the morning. Have a lawyer present." He thanked me. He apologized again. He hung up. I sat at the kitchen table with Marin for a long minute after I put the phone down. "Holt, he is afraid of her. He is not the only one in that house tonight." By 8 in the evening, Sutton Maddox was on a video call with Judge Whitfield to finalize the morning's choreography. They had agreed on the timing. They had agreed on the manner of service. They had agreed that Judge Whitfield would walk over alone, in casual clothes. She would go on her own initiative as a private citizen and a neighbor, not in any judicial capacity. The case was assigned to Judge Carlton. Judge Whitfield was simply hand-delivering a public court document to a neighbor in a way that ensured chain of custody. Judge Carlton had been informed. She had signed off. She had said in her chambers Friday afternoon, "Eleanor, if you want to walk the order over, walk the order over. The neighborhood will benefit from seeing that the federal courts do not stop at the cul-de-sac." By 10 o'clock that evening, Greta had called Nash Caulfield, the senior assignment producer at KUSA Denver. Nash had been a friend of hers since they had played intramural soccer together at Cherry Creek High School in 2014. Nash listened to Greta for 4 minutes. Then he laughed. He did not laugh because the story was funny. He laughed because the story was already done, and he had been waiting for it to walk into his bureau for 9 years. "Greta, I will personally drive the live truck to the cul-de-sac. We will be there at 6 in the morning. We will not air a frame until your dad gives me a green light." By 11 Friday night, only 4 people in the neighborhood did not know what was about to happen Saturday morning. They were Whitney Bramwell and the 3 friends she had told the federal injunction was a procedural nothing burger. Marin and I went to bed at midnight. I did not sleep. I lay in bed beside my wife and listened to her breathe. I thought about every disabled veteran I had treated in 24 years. They had come home from the wars I served in, only to find a neighborhood committee was the last hill they would have to take. I got up at 4 in the morning. I made coffee. I sat in the dark of my kitchen and watched the eastern sky over the Front Range begin to turn pink at 5:11. At 5:30, the KUSA satellite truck pulled into Otto Reiner's driveway with its lights off. Otto met them on his porch in pajamas and a bathrobe with 2 thermoses of coffee. The truck was completely set up by 6:15. At 6:38, the porch light came on at 4194 Antler Ridge Drive. Judge Eleanor Whitfield's front door opened at 6:40. She walked out onto her front step in jeans, the same University of Wisconsin sweatshirt, and a pair of clean leather slip-on shoes. She was carrying a manila folder in her right hand. She started walking. Judge Eleanor Whitfield's front yard at 4194 Antler Ridge Drive faced east toward the Front Range. She walked down her front walk in the lavender first light of a Colorado spring morning at 6:41. Her own grass was still wet with overnight dew. Her shoes left dark prints in the silver where she stepped. She turned right at the sidewalk and walked north along the gentle curve of Antler Ridge Drive. She passed the front yard of the Forsman family at 4202. The Forsman porch light was on. Mr. Forsman, who was a Greek Orthodox priest at a small church in Fort Collins, was on his porch with his coffee. He nodded at her. She nodded back. She passed the front yard of the Hadlock family at 4208. Mrs. Hadlock, a retired Air Force colonel, was at her window. She raised her coffee cup. She passed the front yard of the Brierly family at 4214. The Brierlys had been on Otto Reiner's list. Their daughter Sage, who used a wheelchair, was up at the dining room window in her pajamas. She waved. Judge Whitfield waved back. She stopped at the property line of 4218. That was our house. She looked across the lawn at our porch. Marin was at the front window in her chair, with her right hand pressed flat against the glass. Marin waved with her left hand. Judge Whitfield waved back. I came out onto the porch with my coffee. Your Honor. Mr. Ashford, thank you for the loan of the cul-de-sac. I smiled. I have not smiled much in 14 months. I smiled then. She continued walking north. The KUSA Denver satellite truck, parked discreetly on the gravel apron of Otto Reiner's driveway, was running both cameras with the boom mic up. Nash Caulfield was inside the truck with a headset on, watching every step on a monitor. Otto stood on his porch with his hands wrapped around his thermos. He was not saying anything. She passed the front yard of the Rumsey family at 422. Both Rumseys, who had not been on Otto's list and who knew nothing yet, were not yet awake. She passed the Stickney family's house at 4230. The Stickneys' front door was open. Wesley, the 11-year-old, was on the porch in his pajamas with his sensory tent set up beside him. He stood up when Judge Whitfield walked past. She stopped. She turned. She looked at him. She walked up his porch steps. She set the manila folder down on his porch railing for one moment. She knelt down so she could meet him at his eye level. She said, very quietly, in a voice the boom mic could just barely catch, "Wesley, the Federal Court of the United States has heard your case. I am about to deliver the order. I want you to know that you helped get it written." Wesley nodded once. He did not say anything. Judge Whitfield stood up. She picked up the manila folder. She thanked Wesley. She walked back down his porch steps. Mrs. Stickney was on the porch by then, with her arms folded across her chest, in her bathrobe. She was crying quietly. She did not say anything either. Judge Whitfield continued walking north. She passed two more houses with their porch lights on. By 6:51, she had reached the south property line of 4244 Antler Ridge Drive. That was Whitney Bramwell's house. The lights in the kitchen were on. Whitney's champagne Cadillac was in the driveway. Theron Bramwell's gray Audi was parked behind it. Inside the kitchen, through the bay window, you could see Whitney standing in a quilted bathrobe. She held a coffee mug in her hand and was looking out at the front yard. She saw Judge Whitfield turn up the front walk. The mug in Whitney's hand froze halfway to her mouth. She stayed very still for one full second. Then she set the mug down on the kitchen counter, very carefully, the way a person sets down something they suddenly realize is fragile. Judge Whitfield rang the doorbell at 6:53 Saturday morning. The KUSA cameras were rolling. Whitney Bramwell opened her front door in her quilted bathrobe at 6:54. She looked at Judge Eleanor Whitfield for 2 full seconds before she said anything. The look on her face moved through 3 distinct expressions: confusion, recognition, the slow understanding of a woman who had not, until that moment, fully grasped the address her neighbor at 4194 had been listed under. "Eleanor," she said, "you did not have to walk over." "Whitney, yes, I did." Judge Whitfield held out the manila folder. "This is the preliminary injunction issued at 4:43 yesterday afternoon by Judge Patricia Carlton. She sits on the United States District Court for the District of Colorado. The matter is Ashford et al. Versus Antler Ridge Estates Homeowners Association. The injunction is effective immediately. You have been served. I am hand-delivering this in my capacity as a private citizen of this neighborhood. The court has authorized the chain of custody." Whitney did not take the folder. Judge Whitfield set it on the small entry table just inside the door, the way a courteous neighbor leaves a casserole. "There are 3 things I would suggest, Whitney. The first is that you contact your attorney before 9 o'clock this morning. The second is that you not approach any of the Ashford property, the Stickney property, or the Brierly property. You also will not approach the Crowell property or the Pelham property until further notice. The third is that you do not give any media interviews until your attorney has read every page of the order. Whitney's mouth moved twice without making a sound. Eleanor, I did not know you were. Whitney, I have lived 4 houses from you for 6 years. You sent me 3 compliance notices. You knew what I do. You did not bother to look up where I do it. I would suggest that lapse in research is what happens when a person spends 6 years accustomed to other people not pushing back. Judge Whitfield turned. She walked back down Whitney Bramwell's front step, across her front lawn, and onto the sidewalk. She turned south. She started walking back toward 4194. She did not look back. The KUSA Denver satellite truck began transmitting live at 7 exactly. Nash Caulfield's voice came over the live audio feed I was watching on my kitchen tablet. It was calm and even. Only a producer can keep his voice that way, when the story he has been waiting for has finally walked itself into the right cul-de-sac. This is KUSA Channel 9 Denver. Breaking news from Larimer County. A sitting federal district court judge has just personally hand-delivered a preliminary injunction to her own neighbor. The case is a federal Fair Housing Act action, alleging pattern or practice discrimination by an HOA against multiple disabled residents. The story was the lead segment on the 7 o'clock broadcast. It was the lead segment on every Denver area news broadcast at noon and at 5 and at 10 that day. By Sunday morning, the Associated Press had picked it up. By Monday morning, the New York Times had a national wire story. By Tuesday, Sutton Maddox had received 17 calls from civil rights attorneys in 12 states asking for the case file. Inside our house, Marin and I sat on the porch in the late morning sun. Otto Reiner crossed the cul-de-sac at 10 with his late wife's chocolate chip cookies. The Stickneys came over at 11 with Wesley. The Brierleys came at noon. Sage Brierley wheeled herself up the ramp with her father's help. She and Marin sat on the porch together. Their fathers stood in the front yard, not saying very much. By 2 in the afternoon, Whitney Bramwell's attorney had filed an emergency motion to expedite the entire proceeding. His client wanted to begin negotiating restitution before the federal docket put any more witnesses on the public record. Marin rolled to the edge of the porch at 3. The afternoon sun came across the cedar of the ramp at an angle. It lit the cedar from underneath, the way it had lit Marin's hair the morning we got married 31 years ago. She held my hand. She said the line that everybody at Antler Ridge Estates would remember for a long time. It was small enough that none of the news cameras caught it. Holt, the walk was beautiful. Yes, ma'am. She walked it for all of us. Yes, ma'am. We sat on the porch. The cedar of the ramp held the afternoon sun. The neighborhood had begun, slowly, to feel like ours again. The federal pattern or practice case settled 6 months later. Whitney Bramwell agreed to a consent decree with HUD. The decree paid $480,000 in civil penalties. It paid $110,000 in restitution, divided among the Ashford, Stickney, Brierley, Crowell, and Pelham households. It permanently barred Whitney from holding any HOA officer position in Colorado for life. It mandated ADA compliance training for every HOA board in the state within 24 months. The U.S. Department of Justice issued a written commendation to Sutton Maddox 6 weeks later. Whitney pleaded out on the state criminal charges 3 weeks after the federal settlement: 12 months supervised probation, 120 hours of community service at a Loveland accessible housing nonprofit, a formal written apology to my wife on her own letterhead. The Antler Ridge Estates Homeowners Association called a special election the month after the federal settlement. Otto Reiner ran unopposed for HOA president. He won by acclamation. His first official act was to dissolve Section 8.4 of the bylaws. He replaced it with a 1-paragraph clause requiring the board to comply with all federal Fair Housing Act and ADA requirements. Theron Bramwell filed for divorce 2 months after the consent decree. Whitney moved out of 4244 Antler Ridge Drive in October. I received a personal civil settlement of $240,000 on the property and harassment claims. Marin received a separate $40,000 settlement for the wheelchair pushing incident. We used every dollar of both settlements on one project. The Marin Ashford Accessibility Fund opened its doors in Fort Collins in March. The fund does 3 things. It provides free legal representation for any disabled Colorado homeowner facing an HOA discrimination action. It pays for ADA-compliant ramp construction at the homes of disabled veterans across the Front Range, at no cost to the veteran, and it funds a scholarship every year for 2 Colorado students pursuing degrees in occupational therapy, civil rights law, or accessible design. Greta chairs the board. Marin walked out of physical therapy with a cane on the first Friday of October, 10 months after the bulldozer Saturday. She walked the length of the parallel bars without holding either rail. Her therapist cried. Marin simply turned around at the end of the bars, looked at me and said, "Holt, the ramp goes on the porch as a memorial, not as a need." We left the ramp on the porch. We added a brass plaque that reads, "Built for Marin, July 2024, still holding." We started something else, too. The first Saturday of every June is now Front Porch Day at Antler Ridge Estates. We open every front porch in the neighborhood. The Stickneys host a sensory-friendly play space on theirs. Sage Brierly runs an accessible design demo on her ramp. Judge Eleanor Whitfield reads from a children's book on her porch every year for Marin the librarian. About 600 neighbors come through every June now. Last June, a kid about 10 years old asked me whether the long cedar ramp on our porch was the one from the news video. I told him it was. He asked if his grandma could borrow it. I told him she would not need to. We had built her one in her own front yard last fall, free of charge. If this story made you angry, drop a comment below with your own HOA nightmare. I read every one. If it made you smile, share it with somebody who needs to hear that the federal courts of the United States do not stop at the cul-de-sac. And if you enjoy this kind of story, slow-built, well-prepared, and finished by people who refuse to give up, hit subscribe. The next one is about an HOA Karen who told a Vietnam veteran his American flag was casting visual disturbance over his late son's headstone. The retired JAG officer next door had been quietly photographing every notice for 14 months. I'll see you next week.
What gets me about Amber Holloway isn't the greed, it's the confidence. She listed a man's ranch on her brokerage website without ever speaking to him. She forged county documents on her husband's desk. She brought champagne and a jazz quartet to a stranger's driveway and called it a tour. She did all of that because nobody had ever made her stop. What broke her wasn't a clever lawyer or a viral video. It was a man who saved every letter, photographed every flyer, and built a quiet system over months while she bragged on Instagram. What's patience, paperwork, and Ellie Brooks Memorial Land Trust that has already protected 11 families' ranches in Central Texas from the next Amber Holloway. If an HOA or a developer has ever tried to bulldoze your piece, drop your story below. I read every single one. Hit subscribe because next week we are walking onto a 5-generation peach orchard the morning the HOA president showed up with a bulldozer and a common area garden plan she invented the day before. The retired arson investigator on that property had a very different plan for her afternoon. Don't miss it.